Good morning, everyone. I'm Kristen Smith. I'm happy to be with you here today. And Teresa?
Good morning, everyone. I'm happy to be here as well. Hopefully, we're able to convey some good information for you folks this morning. Thanks for joining us.
Yes, thanks. I know it's early. Probably many of you are in the process of driving to work, getting ready, listening on your phone. Appreciate you taking the time to multitask and listen to us. And we'll get started. I'm going to take the first half of this presentation, but Teresa might jump in from now and then. Just to give everyone a recap, we're here to talk about New York State's new model sexual harassment policy that was released just 2 weeks ago. But all this started back in 2018 when New York State started making a series of changes to its sexual harassment laws, enhancing the protections around sexual harassment. I'm not going to go over all of those changes. They're not all directly relevant to our topic today, but the two that are the requirement that employers conduct annual sexual harassment prevention training. That's been a requirement for several years now. And the requirement that employers develop and maintain a sexual harassment prevention policy that meets the requirements of the law. And so I have a bullet here on the slide, just a reminder, a little plug that Bond does have its own compliant training program that is online and interactive. And there's the link for it there if you're interested in checking that out. It's been a very popular tool for our clients. Next slide, Kathy. So the law that requires you as an employer to have sexual harassment policy and training is Labor Law 201G. And part of that law says that the Department of Labor, together with the Division of Human Rights, has to take another look at that model policy every 4 years. So that's why we're here today. 4 years has passed, hard to believe. And so just a couple months ago in January, the state released a proposed model and they opened it up for public comment for a month. Some of you might have participated in a webinar that Teresa and I did in January, perhaps it was early February, where we talked about the proposed model. And so that was under consideration. And then after the public comment period closed, 2 months passed, and they came out with the final. And that was, as I mentioned, on April 11th. Along with the new model policy that we're going to talk about a lot today, they also released model training with a video, a 54-minute video, a script, and a handout. So Teresa will talk a bit more about that as we get into the presentation. Next slide. I will make one sort of caveat here. For those of you who did come to our webinar in January, February-ish about the proposed, a lot of our presentation today will be the same. Because really almost nothing changed between the proposal and what actually came out, like almost nothing. But so I will not be offended if after hearing that, you hop off, because it really will be largely the same. But we did mix up the slides a bit. We rearranged the topic, the order of the speakers to keep it fresh. And we've also had a couple more months to think about this. So some of our impressions might be a little bit more mature and developed, perhaps, I don't know. But anyway, let's get going. I think the number one thing that you all probably want to know about is, well, what do I do with this? What are my requirements? Is there a deadline? What do I need to do? So let's talk about that first. Let's get that out of the way. The underlying law that requires you to have a sexual harassment policy did not change. And the minimum standards in that law did not change. There's nothing in this release of a model policy that says you must adopt our revisions by X date. There's no deadline. That's been a common question that I've gotten already. What's our deadline to get our policy updated? There isn't one. That being said, this model reveals to all of us what New York State really cares about. It shows us what they think is important in terms of preventing sexual harassment and what the hot topics are. What's changed in our world. So given that the state is gifting us with this insight into what is important to them, and they take far more time than many of us to think about these things, there's going to be a couple areas that we'll point out today where we think maybe you don't have to adopt their exact language exactly, but through and through though, for the most part, best practice to go ahead and adopt it. And what the actual language on the document says that employers are encouraged to tailor this policy to their individual needs, but also it warns that no section in this policy should be omitted, meaning, you got to address retaliation, you've got to address a complaint procedure, those types of things. I mentioned a moment ago that Bond has its own compliant training program. I want to mention here to those of you who use that product that we will be enhancing it to incorporate the state's new areas of focus that we'll be talking about today. We're working on it right now. It's on my to-do list. I think that's next week for me. And we're hoping to have it out this spring. So stay tuned. If you haven't used Bond's product, let us know if you're interested in checking it out. So the next slide, Kathy. I mentioned this already. What's different between February, the proposal, and April, the final? Almost nothing. So I laid them on my desk side by side. Maybe some of you did that as well. Actually, I think I laid them on my screens. But I went through and every single word looked the same until I got to the very end of it. And maybe you didn't see this if you ran out of steam, but at the very end of it, when it's talking about external remedies, there's an expanded discussion of the EEOC's process to acknowledge that EEOC does conciliate complaints. Before that was collapsed into a very short summary. But substantively, in terms of, what sexual harassment is, every word is exactly the same as it was in February. Next slide, please. So this is where we're going to get into the meat of it. We are going to go over a list of areas that are either new or enhanced in this model that you might not have addressed to the same degree in your current policy. They're not in any particular order of importance, but they're, Teresa and I have taken some time to kind of consider what's new and, what that means. And this is how we broke it down in terms of categories. So moving on to number 1. So the first thing that I noticed, and it's the next slide, Kathy. The first thing that I noticed is that while this is a sexual harassment policy, there is a new acknowledgement that harassment can occur based on other protected classes, which we all knew, right? But the law that enable or required the state to come out with this model says that the state is supposed to provide a sexual harassment prevention policy, not a general workplace harassment, that covers racial harassment, disability harassment, et cetera. Their charge is to create a sexual harassment policy. But I think the state recognized that alone is sort of only part of the story, right? So what they did is throughout the policy, they listed the other protected classes saying, and these are 2 quotes, right? While this policy is focused on sexual harassment and gender discrimination, the methods and investigating is the same. And they say, and actually the very final line in the model policy is, the prevention policies outlined above should be considered applicable to all protected classes. So that was sort of like and by the way, this applies to everything else. Now, my editorial on this point is this. I don't think it is the best practice to use this policy as your only harassment policy, even though it now lists these protected classes. And the reason is because, to me, sort of the shoehorning in of the other protected classes feels like an afterthought. It's a little awkward, and it doesn't fully explain those other types of harassment. So I think something is lost. For example, all of the examples that you see in the policy are about sexual harassment, gender-based harassment. There's not a thing about racial harassment. There's not a thing about age-based harassment or disability or the other things that we might unfortunately run into in the workplace. So our practice has been to help clients put together a policy that incorporates the state's model, sexual harassment policy guidance with, the other things that you want to address in terms of harassment and discrimination, and bring it together in one. And so this policy, that's what this new model kind of tries to do, but it's a little awkward. So if you maintain 2 policies, I still think that's a good idea. Or if there's one, you just want to make sure that you're considering all the protected classes in a little bit more detail than this one does. Next slide, Kathy. That's the first way that the new model addresses other protected classes. But then it does it in a way that I think is kind of even more interesting. And that is, it acknowledges that membership in other protected classes might affect how gender-based conduct impacts a person. So there's a lot of discussion in the policy about how the word impact. And I think it's in Teresa's section later where she's going to talk about how this model policy really focuses a lot on how the conduct, that what matters is how the offending conduct impacts the victim. It's a very subjective standard. How does it affect them individually? And what the model policy is acknowledging is that, here's a quote right here, our different identities impact our understanding of the world and how others perceive us. And so your race, your ability, your immigration status may impact your experience with gender discrimination. So someone says something to someone who is perhaps a victim of domestic violence, it might be received differently from someone who is not. And that concept is peppered through the policy, and that's all new. That's all new from the old model policy. Can you advance, please? I wanted to just share a couple other places or pieces where this concept is acknowledged, because I think it's interesting and important. It says that individuals bring personal history with them to the workplace that might impact how they interact with certain behavior. Same concept I just mentioned. And then it says it's important for employees to be aware of how their words or actions might impact someone with a different experience. Again, the idea that the other protected classes someone might carry with them affects how harassment is received. And I think the reason why this is important and interesting in the model policy translates over to the training. I think that's a really important message that should be delivered in training, because I think, there's always that, well, I didn't really mean to offend someone kind of idea. But the thing is, you sort of take your victim as you receive them, and you don't know what they bring to the table. Next slide. And then on the same concept, the state's model policy gives examples of how someone's other protected class might intersect. So it says placing different demands or expectations on Black women employees, more than white women employees can be both racial and gender discrimination. That's kind of obvious, right? But but then it talks about an individual immigration status might lead to perceptions of vulnerability. So it might change how they perceive or react to harassment. And that past experiences as a survivor of domestic or sexual violence might impact that. And I just noticed I missed a quote. Oh, no, I didn't. I put it at the beginning of the first one, at the end of the third. Sorry, I thought I just caught a typo, but maybe not. All right, so that is number one, intersection with other protected categories. And if you have questions, throw them in the Q&A. It's a little hard to look at those while I'm talking, but Teresa is gonna prompt me. The bottom of the slide is cutting off. I don't know what to say about that, but next slide, please. All right, the number two on the list is gender diversity. There's a very noticeable new emphasis on gender diversity. Discrimination, based on gender identity has been illegal for some time now in New York State. And in your current policy, if you have the list of protected classes, hopefully that is already listed as a protected class. So you've got that covered already, right? The difference here is a very, very, very detailed discussion of that concept. That's new. And in fact, it has this long discussion about the gender spectrum and really trying to educate employees on what that means. It goes through the specific terms here, what a cisgender person is, what it means to be non-binary, transgender. And I think this is a recognition that this is a concept that might be new to some employees, that does require some training and some education. And so the model policy takes some effort to address that. So I would say that if your current policy addresses the fact that gender identity discrimination is illegal, you're good. But I do think it is a best practice to beef up that discussion a bit, because it is an area where education is necessary. And depending on your workplace, you can kind of figure out how to address that. The next slide, please. And not only does it provide some definition and discussion, but it also provides some examples and says, and here they are: remarks regarding an employee's gender expression, such as, what they're wearing, what they're wearing is, associated with the wrong gender identity in someone's mind. That could be an example of sex stereotyping, which is unlawful. And I should say that in the old model policy, there was a line that said that sex stereotyping is a form of sexual harassment and gender discrimination. This policy just amps that up, gives it a lot more detail so that people can understand it. Because I do think that sex stereotyping is a concept that needs some explanation for employees and employers. So another example it gives, asking employees to take on traditionally gendered roles, such as asking a woman to serve meeting refreshments when it's not part of or appropriate to their job duties. Raise your hand if that's happened to you. I'm sure it's happened to many people on this line. Intentional misuse of an individual's preferred pronouns. Hopefully by now we know that that is a problem. And creating different expectations for individuals based on their perceived identities, such as dress codes that place more emphasis on women's attire, or leaving parents or caregivers out of meetings under this impression that, you know, maybe they don't have time. So those are all examples in the new model policy that are worthwhile, and, you know, think about how to incorporate that into your policy. Next slide. The third topic that is new is, pardon me while I'm looking at my notes over here, bystander intervention. And so there's always, hopefully, there's always been this concept that you do want employees, if they view discrimination, even if they're not the recipient, to report it. This takes it to a new level. And I see a comment in the Q&A about the length of this policy. So let me just pause for a second and say, yes, this is a very long policy. I don't know, 10, 11 pages. I don't remember off the top of my head. It's a lot. It's more than double of the old one. And so you're thinking, do we really have to have this much detail? No. I mean, you can, if it is too long, I think there's a lot of extra words in it. I think there's a lot of repetitiveness in it, and there is a way that you can scale it back. However, I mean, there are a lot of important concepts, and there's a balance there. And I think there's things that, you know, you will want to incorporate, even though it's going to add some length to your policy. So just wanted to address that question. The reason that question just came to mind is this is an example. Whereas before you might have one line in your policy that says, if you observe harassment, you should report it, even if you're a bystander. This takes it to a new level and has a whole discussion of the importance of bystander intervention. It encourages bystanders to report. It mandates that supervisors who are bystanders should report, or must report. I agree with that. And then it provides 5 standard methods for intervention. And these might be familiar to some of you as what's known as the 5 Ds. There's different sort of takes on this whole bystander intervention concept out in the world. But there is, some sources that talk about 5 Ds, and that would be these. So interrupt and distract. So distract is the first D. Ask a third party to interrupt and distract. That's delegate, the second D. And the third is to record or take notes. That's document. That's the third D. The state doesn't use these D words, so I didn't put it on the slide. But so we got distract, delegate, document. The fourth is to check in with the person who has been harassed. That's delay. That's the way it's described. I think that's a little bit of a stretch. It means after the fact, after there's been some delay, check in with the person. And then the fifth one is direct, a direct approach, which is to confront the harasser. So these are listed in the model policy. Recall in an earlier slide, I said that that what the state is saying is no section should be removed. This is an actual new section in the model policy. So I think I would encourage you to have a bystander intervention section separated out. Okay, next slide. Am I at this is my last one, right, Teresa? Or are you taking this one?
Nope, this one's you.
All me. All right, and then you get to hear from Teresa. So I'm not hogging the screen here all morning. Remote work environments. Obviously, since 2019, when the last policy was issued, this is a much bigger thing. So there is greater recognition in the model policy about remote work environments, just basically saying the behaviors that are illegal in the workplace can also be found to be illegal in a remote work setting. And talks about harassment happening on virtual meeting platforms, messaging apps, and after working hours, posters, other materials in the background of your virtual platform being harassing potentially. So depending on your industry, right? I mean, perhaps you have not a single person ever working remotely. Maybe not relevant, but if you have any bit of remote working, I think it's a good idea to include that in your revised policy. So that's my section of the presentation. Teresa, did you see any questions that are sort of logically answered now?
I saw a couple. So one of the main questions that seems to be repeating is, can we wait till our regular handbook update to update this policy, or is it something we need to do now?
I think you can wait. Like I said at the beginning, there's no deadline. So, but I say that with, you can hear a little hesitation in my voice, which is, if you're not updating your handbook for 5 years, don't wait that long. But if this is a difference between, if you are on an annual cycle of updates and you update it every December, as long as you have the concepts right addressed, right, as remote work aside, because you may not have remote workers, but if you have gender identity addressed, and if you have bystander intervention concept addressed, I think you're okay. But this should be on your to-do list. I don't know that it needs to be done tomorrow. Teresa, do you disagree? Maybe you do.
No, I absolutely don't. I think the state has gone beyond its own minimum standards in several ways in this policy. And I don't necessarily think you all need to rush and update it tomorrow. Now, is it a bad idea to do what the state is telling you to do? No, because that's the only way you can really reassure yourselves 100% that you have a policy that New York State is going to deem to be compliant because it's their policy. But I don't think you need to rush out tomorrow and do it. And Kristen, I will start talking, but there was one question that I thought was really well asked, and it's something I've thought a lot about. So the question is it legal, and should we encourage employees to actually record events in the workplace?
Oh yeah, sorry, I should have addressed that. Actually, can you go back to that slide, Kathy? I think it's one back. Good question. It's almost like I planted you. In an earlier version of the slide, I put an asterisk next to that one for that very reason, because I wanted to address it. I was just flying through and I forgot. That is when I mentioned earlier that there are things that I wouldn't adopt in this policy. That's one of them. I am not comfortable with the idea that we are in policy encouraging employees to report each other. I don't, for a number of reasons, in terms of employee relations. I just don't love that idea of sort of a workplace where everyone is sort of empowered and encouraged to record each other's interactions. Is it legal? Yes, because we are in a two-party consent state, meaning that if one party to a conversation is consents to it being recorded, then you have enough consent. Now, interesting question, right? What if someone is worried about their coworker and wants to help them out by recording something, and they are in a meeting room and they turn on their recording phone and then they leave, and the phone is recording two people who don't know that recording is happening? That's actually illegal. And that, right. So because the person who's consenting to the conversation isn't part of the conversation, so they can't consent to it. So that can open up a can of worms. So if I were to put these 5 methods of bystander intervention policy, I would mention documentation, but not recording. Teresa, agree?
Agreed, or I'd put some caveats after record. For example, if you're in a hospital or medical setting, recording, except remember, recording is prohibited in patient care areas, things like that.
Great point.
It's a complicated issue, not the least in which because the National Labor Relations Board takes the view that employees should be able to record safety violations in the workplace. So I hesitate a little bit to say, you can put something in there that just says don't record at all. But I also hesitate to say that you should put something in your policy that actually encourages it. So it's a tight line to walk, and I think it's a very good question as asked.
Great question. Yeah, I would definitely not put don't record. I would not do that. That introduces a host of other issues. I think staying silent on it keeps you out of trouble. That's my 2 cents.
All right, Kathy, if we could go 2 slides ahead. Okay, so I saw a question that is getting asked a lot, and I'm just going to answer it for the group. The question is, will the slides be available after the presentation? Yes, they are going to be made available later today on our website, along with the full presentation, which is being recorded. So please feel free to check that out. Please feel free to share that as you would like. So I'm going to be talking about New York State's elevated standard a little bit. So back in 2019, we know that New York State abolished the hostile workplace environment standard that we had long had, and that was comparable with federal law, which said that you needed to have a severe or pervasive hostile working environment. So New York changed that and said anything that creates inferior terms, conditions, or privileges of employment and rises above a petty slight or trivial inconvenience is going to amount to harassment. So this new model policy addresses that, and I think goes even farther by saying generally any behavior in which an employee or covered individual is treated worse because of their gender, perceived or actual, sexual orientation, or gender expression is considered a violation of the employer's policy. I think there's a lot of play in the joints with the treated worse language that's underlined and in italics there. You know, I think, and this is one of the themes I'm going to talk about a lot in my upcoming slides is, you know, has the state gone too far in basically saying that anytime you don't like something, you can now claim that it is harassment? I myself think they have trended towards that line, especially when we talk about some of the victim impact things that we're going to talk about. But, you know, this I think is a real flavor for where New York State is at. You know, I mean, they're encouraging anyone who feels they've been treated worse to file a complaint with one of their agencies. And I'll talk more about that in a couple of slides. So next slide, please, Kathy. So one of the important things that I think we see throughout the new model policy is this concept, and Kristen mentioned it, of impact over intent. And this is something that has kind of been percolating in the harassment space for a while, this concept that a person's intent doesn't matter nearly as much as the impact of those actions or words on the person experiencing them. So for example, using the common defense, I was just joking, doesn't neutralize a harassment claim. It clarifies that not intending to harass is not a defense, and the impact is what counts. I think this is really important when you're doing your trainings to emphasize with your employees, because I do continue to hear, you know, I didn't mean it that way. I hug everyone. I was just joking. I didn't know any better when I said that. I didn't mean it. You know, those types of things really don't save the day or even carry the day when we're talking about the strength of a sexual harassment claim. New York State has put so much emphasis on this that the word is used nearly a dozen times throughout the policy. And so I think, you know, for employers doing these investigations, this is really something to keep in mind. Next slide, please. There are additional practical examples added really for retaliation. So we know retaliation is prohibited, and retaliation is when you take an adverse action against somebody for making a complaint or supporting someone else and making a complaint of discrimination or harassment. And so they've added in the new model policy some additional examples of things that can be retaliatory. And a lot of them make sense, right? Like demoting someone, terminating someone, denying them a reasonable accommodation, reducing their hours, or giving them a less desirable shift. Those are all going to be examples of retaliatory acts. Publicly releasing personnel files, that's something I've never seen an employer do. I'm not sure that many of my colleagues have, but I understand why they included it here because actually, fun fact, New York State released a policy on this not so long ago. So they are really looking at not releasing personnel files in a vengeful way. Refusing to provide a reference or providing an unwarranted negative reference, we know that. Disparaging someone on social media. Labeling an employee as difficult and excluding them from projects to avoid the drama. You'll see there's an asterisk next to that one. I think that really is a slippery slope and is one of those parts that perhaps moves the needle beyond what could ever be considered legal sexual harassment. You know, over and over we see in the case law that the harassment laws are not meant to be a civility code for the workplace, right? They're not meant to prevent anything that people just don't like. They're just supposed to prevent harassment. And so I think that the inclusion of something like this really pushes the line a little bit on that. Undermining an individual's immigration status would be a retaliatory act. Reducing work responsibilities, passing over for a promotion, I think that makes sense. And then another asterisk is moving the individual's desk to a less desirable location. I had a federal court case where this was one of the allegations of retaliation. The individual claimed that their desk was moved to the basement, and they said that this was a retaliatory act, and the court found that that is not enough to have a retaliatory act under New York or federal law. So I thought that was very interesting. And then when I saw New York included in the model policy, I was surprised that this is coming up so often. New York felt the need to include it for everyone. So that's another one where I'd say, listen, if you have someone complaining that you moved their desk, I'm not sure you need to be so worried about a legal retaliation claim. But if you have this language in your policy, it's a bet that employees are going to see it that way. Next slide, please. So some additional practical examples were added. This is one of the few that targets a specific industry. So sexual advances or pressure placed on service industry employees by customers or clients, especially in those industries where hospitality and tips are essential to the customer or employee's relationship. I thought that was an interesting add and kind of one of the only parts of this new model policy that's targeted at a specific industry. And then repeated requests for dates or romantic gestures, including gift giving. That's long been viewed by the Division of Human Rights as a type of sexual harassment, where somebody keeps getting asked out in the workplace over and over and over, and they keep saying no. Someone keeps making romantic gestures towards them. I had that case before the Division of Human Rights about 5 years ago. And so I know that's been a long-standing theme for them as well. And then same thing with questions or comments about somebody's romantic or sexual history. Next slide, please. One of the things Kristen mentioned, and she's right on the money, is this emphasis on external remedies. And when we say external remedies, we mean the federal and New York State administrative agencies and courts. Obviously, as employers, we want to encourage people to make internal reports so that we can, investigate and figure out if there's a discrimination or harassment problem within our organization. New York State also really, really, really wants people to know that they have other options. There's some language in the policy, and I've quoted it for you here, that says an employee or covered individual who prefers not to report harassment to their manager or employer may instead report it to the New York State Division of Human Rights or the United States EEOC. And then it goes on to say complaints can be made both to the employer and the government agency. This option on external remedies and how we file for relief in federal or state court has been moved up in the policy. If you remember, in the last model policy, it was kind of towards the end, and there still is a long section on it towards the end, but it's also mentioned very prominently up front under page 1's section on goals of the policy. So I thought that was interesting. I saw in the questions, somebody asked, the external remedy section is really long. Do we have to include every single thing that the state says about external remedies? And I don't think that's the case. I think as long as you meet the minimum standard, which is to inform employees of their rights of redress and all available forums of adjudicating a sexual harassment complaint administratively and judicially, you've met the burden that you have to show. Next slide, please. The sexual harassment prevention hotline is not necessarily as new as the other things in the policy, but it is new in that it's included in the policy. So this is the New York State Division of Human Rights 1-800-HARASS-3 number, which for those of you who don't know, provides a referral to a volunteer attorney experienced in sexual harassment matters who will provide limited free assistance and counsel over the phone. And you get that just by calling that number. It's run by the Division of Human Rights and it operates during regular business hours. Now, what Kristen was saying is true. You can wait or likely can wait to you're doing your regular refresh or update of your policies to add in most of what we're talking about. This one should already be in your policies. Just this specific issue about the hotline should already be in your policies because this was actually part of a separate legal mandate that was passed in the spring of 2022, which mandated that this information be included in your sexual harassment policies. So if you're going to update nothing else right now, please ensure that that is in there. Next slide, please. There's a new emphasis on special responsibility of supervisors and leaders, and that's not so earth-shattering, I don't think. I will say I think one of the main reasons that this has been emphasized is because the Division of Human Rights is placing a greater emphasis on naming individuals in addition with employers as respondents or, defendants in the complaints that are brought by individuals with that agency. So it makes sense that they're putting more of an emphasis on supervisors in their model policy. So we know managers and supervisors shouldn't be passive. They shouldn't wait for an employee to make a claim of harassment. I always say, and this goes with the bystander section, if you see something, say something. And if you're a manager or a supervisor, you must say something. One of the interesting things about this section, and it brings up a running theme throughout the policy, is this concept of re-traumatizing individuals through an investigation, or kind of re-traumatizing individuals who are being identified as possible victims. And so there's a lot of language about supervisors and managers needing to accommodate the needs of individuals who've experienced harassment to ensure the workplace is safe, supportive, and free from retaliation, and that they should be mindful that questioning about harassment and discrimination can be intimidating, uncomfortable, and re-traumatizing for individuals. There was none of this in the original model policy. There was just, you get a complaint, you do the investigation. All this concept of re-traumatizing a victim through an investigation is new to the model policy, and I think it's a really interesting addition. So if we go to the next slide, I'll talk a little more about that. So this emphasis on victim trauma really runs throughout the investigation section. And it's used, the actual language of, re-traumatization is used. And there's a lot of edicts placed towards the employer and supervisors to be mindful that harassment and then subsequent investigation can be traumatic for victims. So this is a shift in tone. I am a little concerned about where this could go. I mean, just so you know, there are many attorneys at our firm that do harassment investigations and other type of workplace investigations. Kristen and I probably do them more commonly than some others. And I know that, there's going to be a day, probably not so far down the line, when an individual claims that they've been sexually harassed and then re-traumatized by the investigation and the questions being asked during the investigatory interview. Or, what if an individual just says, I'm too traumatized by what happened to me to be interviewed at all? I think those are going to be real questions employers need to grapple with. And in that way, it's probably a good idea to think about what your responses to those things would be. I have some ideas, because we do have an obligation to conduct a full and fair investigation. And that's going to be very difficult if the individual claims that they're just too traumatized to be interviewed. Next slide, please. Some other interesting tidbits. There's a lengthy statement on purpose and goals. We talked about that intersectional focus that Kristen mentioned, emphasis on other types of harassment and identities, and then this new emphasis up front on external remedies. There's also an expanded list of non-employees who are covered. So we know that this applies to everyone that your employees interact with, whether that be in the workplace or outside of the workplace. Typically, the policy had said something like independent contractors, clients, customers, visitors, things of that nature. Now they've added equipment repair, cleaning services, or any other services through a contract. So they're just pushing, to make sure employees understand that it covers everybody and not just them and their colleagues. There's an explicit statement that you don't need to use the complaint form to report. You may recall that New York State has released a model complaint form that is not changed between 2018 and now. It is still the same complaint form, but it is something that you have to distribute to your employees annually, just the same way you have to distribute a copy of the policy annually. You don't need to use the form to report sexual harassment. I would encourage it as an employer, but you certainly can't ignore a sexual harassment complaint just because somebody didn't use the prescribed form. The state adds that the New York State policy can be distributed via email. I would encourage you also to put it in your handbook. I saw a question in the chat when I was looking at it about posters. New York State has released a poster for sexual harassment. It is not something that you have to display. Your only obligation is to distribute the sexual harassment prevention policy and the complaint form once a year. I generally recommend employers do that with their training. Next slide, please. And that's what we're going to talk about next. So Kathy, if I could have the next slide, we'll talk about the training. So although the state released a revised model policy in January, it didn't release a proposed revised model training in January. So a lot of people asked me the question back then, well, they're changing the policy. What are they going to do with the training? And the answer was, I don't know. But then on April 11th, when the revised model policy came out in final, they released a training and kind of surprised us all a little bit with that. So it's no surprise, though, that the training largely mirrors the revised policy. However, despite Kristen's apt analysis on intersectionality, the training really only addresses sexual harassment and not other types of harassment. Next slide, please. The former training was 2 videos, 19 minutes of instructions, and 22 minutes of case studies. The revised training is 1 video and is longer than the 2 combined videos, and it has both instructions and case studies. Interestingly, the accompanying script and PowerPoint slides are included in the training materials. If you go on the New York State website, you're going to see a whole training toolkit or training packet, and it'll have all the information for you there. Next slide. There is a requirement, Kristen mentioned this already, that a training be interactive in order to fulfill New York State requirements for sexual harassment training. As they had stated back in 2018, simply having an employee view the video on their own is insufficient to meet that interactivity requirement. There were a lot of questions formally about what we could do to make a training interactive. Now, New York State has released its solution to that issue, at least potential solution to that issue, by releasing a form for employees where they can answer true or false questions relating to the case studies in the model training. So New York State says when that form is completed by attendees and submitted to the employer, this fulfills the interactive requirement. As Kristen mentioned, Bond will be updating its model training, and that in and of itself fulfills the interactive requirement, because as you go through the training, it prompts you to answer questions and input your own thoughts. So that one already fulfills the interactive requirement. So please just don't walk away from this thinking that all you have to do is press play on the video and your employees will be good to go. You do have to find some way at least to fulfill that interactive requirement. Next slide. All right. So Kristen, any questions? We have 1 minute left here.
I have no idea if I've been visible this whole time, but if I've been looking to the side, looking very diligent, it's because I've been trying to type answers to these questions. We have a lot of questions. So I have been trying to answer them in the chat as much as I can. I do think we're just, we got 1 more minute here. And there's just so many questions. But here's one. Should unpaid volunteers receive the policy and training?
That's a good question. You know, should your volunteers and your contractors receive the policy? I would recommend giving it to your volunteers, frankly. They're going to be people in your workplace working with your employees. Do you have to give it to them? No. Should you give it to them? Yes, I think you should.
Good. Another one, well, based on these new laws, do we have any guidance on conducting investigations? That's actually a really good segue. So I wanted to mention before we signed off, before we lost most of you, that Bond's annual workplace seminars coming up will be in a whole bunch of states, upstate and downstate New York, with our full day of presentations. And one of the sessions in the seminar is for workplace investigations. So we'll be covering it there. Another one is about employment discrimination updates. So I think we'll be talking more about a lot of the issues here in the chat. I know I'm going to be presenting that topic in Syracuse. I don't know who's doing it in Rochester, but we'll be in all the states, or I'm sorry, not all the states, all the cities of the state. But we're really out of time here. We should learn our lesson to schedule these for a full hour, but people need to get on with their days. But thank you so much for joining us. I will take note of these questions. I host the weekly webinar for the firm every other Tuesday. And so I will look at the questions and maybe we can cover some of that in our weekly webinar on Tuesdays. So thanks so much. Any closing thoughts, Teresa?
No, thank you, everyone. Feel free to reach out if you have other questions, and please join us for Workplace. I myself will be in Corning and Rochester, so come on out.
All right, thanks, everyone. Bye-bye.